Hi guys, it's Tracey from Cape Etc. and I'm here to tell you more about the Van Breda trial. Henri has been charged with the murder of his mother, Teresa, his father, Martin, and his brother, Rudy, and he's been charged with the attempted murder of his sister, Marilee. The case has been closed in terms of leading evidence as well as legal argument. We've produced a graphic and we've got the scales of justice because as from the very start of this trial, I've told you that it really is going to be a balancing of the two versions and deciding which side is heavier. So the strong points for the defense are that Henri testified. This is not taken lightly by any of our courts. He's withstood cross-examination. In most material aspects, his story has always been that it was an intruder, that he fought the intruder off. Although he's added bits and pieces to it later on, his version has always been consistent. There were times where details he can recall very specifically, and then other details which you would think was important he couldn't recall. He didn't have any good reason for Judge Desai's questions on why he didn't help his family. Is that reason to convict him? Probably not. The DNA evidence has been attacked on two bases. The first is a technical basis, where the defense has rightly stated that our South African forensic labs are not accredited. And there's case law that the defense quoted from 2001 where the judge said that they should be accredited. And accreditation is an audit process. The defense has said because the lab is not accredited, we must be careful to add any weight to the evidence. Then the second technical point is the proficiency of the analyst. The analyst, Colonel Otto, failed a proficiency test. And then the third technical point is that the standard operating procedures weren't followed. There were certain DNA samples that were taken and weren't properly sealed. Insofar as the box being tampered with, it probably wasn't the case. The defense has said, just based on these 3 points, you should exclude the DNA evidence completely. The case law supports this. This is a difficult decision for Judge Desai to make, because if case law says that you need to be proficient and you need to follow SOPs, then you have to disregard the evidence. The problem with the accreditation is that if Judge Desai were to say that all the DNA results should be disregarded, then every single matter that is currently before our courts using DNA would have to be disregarded. In the alternative, if the evidence is admitted, the DNA evidence actually supports Henri's version. Henri's version is that he witnessed Rudy and Martin being attacked, and he's got the blood spatter DNA of Rudy and Martin on his shorts. He doesn't have blood spatter DNA of Marilee and of Teresa. He only had one blood spot on the heel of his sock from Teresa. The defense got the blood expert to concede that the reasonable possibility would be that it dripped from the axe when he was holding it, or it dripped from the stairs. The fact that the DNA evidence doesn't show any other DNA from Teresa or Marilee, and his version is that he didn't see them getting attacked. Then the second thing, Henri's DNA was not found on any of the family members, and 216 samples were taken to test for DNA, but only 150 or 155 samples produced DNA results. The defense is saying you can't say there was no unknown DNA because there were some samples that didn't produce any results. The most important, and where we go to the second axe, is that Marilee's DNA was not on the head of the axe. So one of the reasons that the state have argued for the lack of Marilee's DNA is the amount of times that she was hit with the axe. And I'm actually going to read it out of the hex of argument. Hubert testified that in order to create blood spatter, a blood source is necessary. This forms when the victim is hit repeatedly in the same spot or in very close proximity, and Marilee was hit at 6 different places. So it sounds like he's saying that because there was various areas that she was hit, this might have reduced the amount of spatter. She was the last victim to be attacked, and there was already a lot of blood on the axe, that it might have affected the transfer of her blood to the axe. This gave the defense an argument to introduce a second weapon as well as an intruder. So now the judge has to say, well, do I accept that as being a plausible reason for the lack of her DNA, or is it that there was another weapon? And that explains why her DNA wasn't on that axe, and that also supports Henri's version that he wasn't there when she was attacked and that there was two intruders, because the second intruder must have been the person with the second axe. Judge Desai also notes then that means that this second intruder fled the house with the second axe because it wasn't found in the house, and then we go back to the point that there's no evidence of anybody having fled with a weapon covered in Marilee's blood. Then the third point for the defense is that an alarm was triggered on the boundary at 3:37 that night. I believe that the security is more on the state side. Holistically, it's unlikely that somebody came in through the gate. Then the fourth point, Henri was diagnosed with juvenile myoclonic epilepsy shortly after he provided his testimony. An expert who was a neurologist, Dr. Butler, told the court that it was probable that Henri had actually suffered a tonic-clonic seizure. It explains the 2-hour, 40-minute lapse, because if you have this type of seizure, you could lose consciousness or lose your memory for a number of hours. Once you've regained consciousness, you would be in a post-ictal state, and this would make you dull and slow and limit your cognitive abilities. This provides a reasonable explanation for Henri having passed out for 2 hours and 40 minutes. It also supports that when he was on the telephone call that he remained calm and that he might have been slightly dull and his senses were dull. This would explain, Dr. Butler said, why he didn't run for help. And it would also explain why he may not have given certain details to the police, because he would have still been in a post-ictal state. The state is not disputing that Henri has epilepsy now, but this doctor is now diagnosing what happened 3 years ago. So the seizure diagnosis is also based on whether or not Henri's telling the truth. But the state is saying, well, you know, everything he needed to tell Dr. Butler when he found out that he had epilepsy, he could have Googled on the internet. Then not all of the shoe prints were tested on the scene. The defense says that 35 shoe prints were tested and they all matched all of the shoes that went through the scene, being the paramedics and the police, etc. But that there were a lot more than 35 shoe prints on the scene. But the state has given a reasonable explanation, and they've said, we don't take every single footprint. If we can see a trail of the same footprint, we won't test every single one, because it's reasonable to infer that the trail was from the same person. The sixth point for the defense is that there was foreign hair found on the scene, although I don't think that the evidence of the hair expert is going to be accepted at all. He wasn't a good witness. The seventh point is Henri's statement that he made to the police. So although the state has argued that he amended it to explain certain incriminating evidence against him, the defense has said, well, actually, he did give his version. It's been consistent. 3 years ago, that's what he said. He's still saying the same thing. There is more detail, but he was in a post-ictal state, and that the officer who he spoke with had paraphrased what he had said. Now, I think Judge Desai will accept that, because he did note that Henri clearly has a good command for English. This isn't consistent with the statement. The English is quite bad, and it's clear that an Afrikaans person was taking down the statement, and that's possibly where the discrepancies came in. There's been a lot of reports in the media about Henri's charges for possession of marijuana, about him possibly having gone to rehab, about reasons why he left Australia, but none of this is evidence before the court. As far as the court is concerned, the evidence is that this was a normal, close-knit, loving family. This was confirmed by both of Henri's uncles, by Bianca, who was a close friend of the family, and by James John. So there really is, as far as the court is concerned, there isn't really a reason for Henri to have acted the way that the state alleges that he did. And the defense also said that Henri and Marilee had both been WhatsApping their respective boyfriends and girlfriends that evening until about 10 o'clock, and neither of them had mentioned an argument or something that was happening in the house. So the final point that the defense raised, and it's not a very nice one to speak of, is there's a picture of the toilet bowl, what Henri had left behind in it and not flushed. Henri's version is that he got up to go to the bathroom and he took his cell phone. and he was using the toilet when he heard the attack. And the defense says he didn't bother with niceties. He got up, he didn't wipe himself. There was also stains on his shorts that he was wearing. So the defense is saying the state wants you to believe that he went to the bathroom, did this, didn't bother with niceties, and suddenly decided to run downstairs and get an axe and attack his family. So Judge Desai is going to give his judgment on the 23rd of April. So we've got just over 2 months to wait until we hear what Henri's fate is.